everyone. Welcome to Crime in Court. This is another episode of, as you can see from the thumbnail, Commonwealth versus Karen Reed Trial 2.0. And we are going to be going through the motions in limine. This episode, we're going to be going through the bad character evidence. So, just recently, yesterday, the 11th of March, a whole bunch of filings came out, like bombardment of filings. So we're going to break them down in separate videos as to, not do them all in one. All right. Yesterday I did I think it was the first yesterday. Yeah, yesterday I had two episodes. One was about it was I read through the latest installment of the Mark Betterow letters, which are just epic because he's just a wordsmith. He's so good with words. And he brought up the fact that there might be some wiretapping charges that should be charged against Chris Albert for illegally getting some audio of Turtle Boy in the street, which they're trying to charge him on. So it kind of backfired in Chris Albert's face. So they're calling for an investigation into Chris Albert for wiretapping. So that's happening. And then, so that was one episode that I did. And then another episode that I did yesterday was the motion in limine trial exclusions. And I accidentally overlooked one of the exclusions. So I want to catch you up on that first before we get started on the bad character evidence. So please hit the like button and let's get started. This is the Commonwealth's motion in limine to preclude reference to and redact the manner of death contained on the victim's death certificate. So again, this happened in the first trial. Remember, the death certificate of John O'Keefe, the manner of death, says undetermined, which doesn't help their case for a homicide, does it? No. So they want that redacted from the certificate again. I believe they did get their way last time. If I remember correctly, I think they were able to redact the undetermined. I can't remember now. So much has happened since then. But anyways, at least they're attempting to do that again, and this is their motion. The Commonwealth moves in limine in accord with settled practice that the death certificate be redacted for the means and manner. Means and manner, they want both redacted. In this case, the means and manner of death on the death certificate is undetermined. So they want both of those redacted. We have stated that with respect to the admission of death certificates, the better practice is to redact the manner of death, such as the words homicide, self-homicide, or an accident. That's coming from this Commonwealth versus Wallace. But where do they say undetermined in there? Nope, I don't see undetermined. So they're misstating or misquoting or misapplying the case law, whatever you want to say. So general law 46 section 19 as amended through 1996, I don't know, chapter 478, and as now amended, see whatever, whatever the statute is, provides that nothing contained in the record of a death certificate, or nothing contained in the record of a death, which has reference to the question of liability for causing the death, shall be admissible in evidence. In a criminal trial, excluding the death certificate, the words homicide, self-homicide, or an accident, or in the case undetermined, is the better and safer course. Well, no, you're just adding that word. They're adding undetermined to this case law that doesn't ever talk about undetermined. It only says those other three words. So he's misapplying this case law. Where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is dead, the question of liability is left solely to the trial jury. For the above reasons, the Commonwealth asks this court to preclude any reference to and to redact the manner of death contained in the victim's death certificate. So again, they're trying to redact John's manner of death, which is undetermined, because the Emmy wasn't persuaded by Michael Proctor trying to get her to change it, and she left it undetermined. So thank goodness for that. All right, so let's move on to the Commonwealth's limine to preclude reference to any alleged bad character and any prior misconduct of the victim or any witnesses. So no misconduct from Michael Proctor, Brian Tully, Yuri Buchanan, no bad character evidence from any of the witnesses like Jen McCabe. Like, what? Are you serious? This is ridiculous and should be denied on its face, because that's exactly the whole point of cross-examination, is to impeach your witnesses, impeach the state's witnesses. Because their witnesses are so bad, they have to put in a motion to say, please, Your Honor, don't let the mean bad defense question our witnesses about any of their wrongdoings. It's just not fair for us. This is really this is where we're at with this trial. Just saying. All right, so now comes the Commonwealth and moves this court to order counsel to refrain from making any reference before the jury or any alleged bad character or alleged misconduct of the victim or any witness without prior court permission. Specifically, the defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims of bad acts by the Commonwealth witnesses. Wow. At the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutors, the court, the trial court employees, and witnesses are corrupt. They are. They are. Declaring that virtually every civilian witness, no, they're not saying every civilian witness, a small portion of the civilian witnesses, but yes, there's a group of them. Police officers and first responders were complicit in the cover up of evidence and implying that nearly every witness is a liar. Well, many, many, many of them are, or have been coached by the prosecution. Such allegations have no foundation nor bearing on any issue in the case and would constitute impermissible bad character evidence, but it came out in trial on cross-examination how shady and untruthful these people are. So why can't we bring that up in trial number 2? That makes no sense, because it came out in cross-examination the way that these people are not reliable and have done other bad character things. All right, so whether during the opening statement, during cross-examination of any Commonwealth witnesses, during direct examination of the defendant's witnesses, or during closing arguments, defense counsel should be restrained from making such references unless obtaining prior court approval. So he wants to block them from opening statements, cross-examination, direct examination, and closing arguments to say anything bad about any of the witnesses, because their witnesses are so bad. They have to put in a motion to say, please don't talk bad about my witnesses. This is ridiculous. A judge may properly exclude evidence that is introduced merely to show the bad character of a witness. Further, evidence of prior misconduct may not be used to impeach a witness's credibility except by production of records of criminal convictions pursuant to the limitations and requirements of General Law Chapter 233, Section 21. A trial judge has the sound discretion to determine whether prior bad act evidence is relevant and whether the probative value of such evidence is outweighed by its prejudicial effect. The judge's determination will be upheld absent palpable error. No error where judge excluded evidence regarding victim's bookmaking activities and prior arrest. Judge properly excluded evidence that victim stole a watch of the defendant. Impeachment by a prior bad act that demonstrates lack of character is not permissible and invites misuse of the jury. No error where judge excluded evidence that witness was not a good mother in an infant homicide case, even where defendant claimed witness was the real perpetrator. So he didn't allow evidence in when there was bad evidence against the mother. I don't know, that doesn't make sense to me. All right, evidence irrelevant to the issue at trial or to the witness's reputation for truth and veracity is inadmissible to impeach a witness. Any bad character evidence is of infidelity, propensity to consume alcohol, or the defendant's suggestion without any factual support that every witness is a liar or participant in an unfounded scheme to frame the defendant has no bearing on any of the issues raised in this case. It doesn't? People lying? People lying in this case or scheming to frame an innocent woman, that doesn't have any bearing in this case? Excuse me, sir? What? I I, I can't. I can't with Hank. I can't. I want to rip my hair out with him. The defense should not be permitted to introduce bad character nor specific bad acts of the victim or any witness. The proposed evidence only serves to disparage the victim's and the witness's character and to distract the jury. And that's the end of that. I can't, I mean, it speaks for itself. My lying witnesses aren't allowed to be asked about their lies, even though it has everything to do with this case and the framing of an innocent woman. Don't ask those questions. Just don't ask them. They're bad for my case, Your Honor. So can you block the defense from asking those questions for me? She better deny that. But this is Bev, and I have no faith. No faith in Bev to do the right thing. All right, this next one, the Commonwealth's motion in limine to admit the victim's out of court statements relating to his state of mind. So this goes to bad character evidence towards Karen Reed. So he's saying, let's keep out all the bad evidence of my witnesses. However, let's bring in all this other stuff that we could consider for bad character evidence for Karen Reed by bringing in the victim's out of court statements relating to his state of mind, because they want to bring in, the fighting that they were doing, the back and forth, and how he was like, I'm just done with all this arguing and stuff. But then he calls her to come over that night. So, or texts her and tells her to come over that night. So, and they take his statements out of context and out of context of like the whole greater picture. We actually read through all of the text messages that Karen Reed and John uh, had the entire day up to January 29th, because that was released as an exhibit. We read through all of them in a previous episode on my channel. I'll try to look for it and put it in the description if I can find it. So yeah, so they're trying to take these texts from John where they're fighting, they're upset with one another, they're angry about the Aruba chicks, who that's a whole nother thing. Um, that, and we're going to talk about that shortly because I think that's the next motion in limine, which is the bad character for the defense. So, all right, so here we've got the Commonwealth motion in limine to admit the victim's statements for his state of mind. The Commonwealth moves this honorable court to allow this evidence, John O'Keefe's statements to his niece, nephew, family members, so they want to call his niece and nephew again to the stand, which was pointless in the first trial. Everyone who was there said it was pointless and that didn't really help their case all that much, and it was terrible to put the kids through that. But here they are wanting to do it again. They want the statements of the niece, nephew, family members, and friends regarding the defendant's intention to end his relationship with the defendant and statements about the tumultuous nature of their relationship, which are relevant to the victim's state of mind. However, whatever he might have said about wanting to end the relationship, whether it's true or not, whether he actually said that or not, he was calling her that night, telling her to come out with him and come back to his place. So, regardless of what family members and whoever heard from John's mouth, his actions speak differently. So, you can bring in all this if you want, but all it shows to me is that you guys are reaching. The broad rule of hearsay, or the broad rule on hearsay evidence, interdicts the admission of a statement made out of court which is offered to prove the truth of what is asserted. So you're not bringing in the the statement for the truth of what is said, but for state of mind. However, declarations out of court may be admissible to prove the state of mind or intent of a person when it is of material issue. The state of mind exception to the hearsay rule calls for admission of evidence of a homicide victim's state of mind as proof of the defendant's motive to take that victim's life when and only when there is also evidence that the defendant was aware of the state of mind at the time of the crime and would likely respond to it. So, again, I say he called her there. He asked her to stay at his place. So, whatever state of mind he had at the time was he wanted to at least continue the relationship or work on the relationship. He wasn't altering, besides like being aloof and not wanting to argue and talk about the things that they argued about, but throughout their text messages, he never said, "This is over, I'm breaking up with you," nothing. There was none of that. So, his state of mind and his intent was for her to stay over that night. So, where they get intent and state of mind, like he was going to break up with her and she knew that, and that's why she took his life, that's ridiculous. And it was ridiculous when they brought it into the first trial as well. It's very hard to grasp as a motive. A homicide victim's attitude or contempt or hostility towards the defendant when it is known to the defendant would constitute some evidence which are augmented by other evidence might warrant a fact finder's determination that the defendant responded by taking the victim's life. There need not be direct evidence that the defendant learned of the victim's state of mind so long as the jury could have reasonably inferred it. Where the jury were warranted in inferring that the defendant knew of the victim's state of mind, evidence of the victim's statement was admissible to show both the victim's state of mind and the defendant's motive to take her life. The Commonwealth intends to introduce statements that the victim made to his family members and friends close in time to the homicide about his relationship with the defendant and his decision to terminate the relationship. If you recall, the Aruba thing happened New Year's Eve. And so that's January 1st, right? December 31st to January 1st. They were in Aruba. And then he lost his life on January 29th. So they were still dealing with the fallout of him kissing another girl and her walking in on that and feeling like she was being taken advantage of because she was in the room with his kids, his niece and nephew, while he was out drinking and partying and kissing some other woman. I'm sorry, John, rest in peace, but if you did it, you gotta, he wasn't a saint. Let's just put it that way. So, yeah, am I missing something? They were having issues. Yes, they were dealing with the fallout of that. Yes, she was feeling hurt and depressed, I'm sure. She was probably questioning the relationship, like, why am I with some guy that's gonna use me to watch his kids and go make out with people and drink. I'm sure that's what she was thinking. He was kind of a ladies' man, if you couldn't tell. I'm not saying that he was a cheater or anything like that, but women loved him. And even the married ones that are witnesses in this case. Jen McCabe, I'm talking to you. So everybody, liked John. Carrie Roberts too, I think, has a thing for John. But anyways, um, let's move on. So I just feel like I'm in the Twilight Zone yet again. Commonwealth contends that the victim's state of mind is relevant to the defendant's motive to take his life. The defendant and victim's relationship had deteriorated, and the defendant also made similar statements about the discord and disdain in their relationship, and the defendant herself had begun to engage in romantic and flirtatious communications with other men. So they want to bring her texts with Brian Higgins into, I'm sure. Adequate evidence for the jury to infer that the defendant was aware of the victim's plan to end the relationship. Proper evidence of threats and discord in relationship demonstrated respective states of mind and victim defendant. Defendant's statements and actions, including heated argument with victim in week before homicide, permitted inference that the defendant and victim had communicated hostile intentions towards each other. Okay, but explain why they were all lovey-dovey in the bar and, like, being affectionate with one another, if that's the case, that he wanted to end things. Because he was affectionate too. It wasn't just her. So, defendant's statement to others concerning agreement with victim over their relationship, coupled with victim's willingness to tell third parties that the relationship with defendant had deteriorated, permitted inference that the defendant was made aware of the victim's state of mind. Whereas the defendant has repeatedly accused others of committing homicide, the jury should be permitted to consider all evidence that demonstrates the relationship and hostility between the defendant and the victim at the time of the homicide, where the defendant described the homicide as an accidental shooting. This is referring to another case. Um, the pieces of evidence and victim's statements considered together and in the context of the location and manner of the victim's homicide provided the jury with a uh, provided the jury with a sufficient foundation to reasonably infer that the victim made the defendant aware of her desire to end their relationship. I don't like how Hank always likes to just throw in a quote from some other case and it's not like in context with the rest of the sentence. He just throws in like these snippets and they're not relative. He does that a lot. The probative value of the victim's statements is relevant to the defendant's motive to take his life. And in a normal world, I would say absolutely sure. But in this case, they had a fight. There was an Aruba thing. There was an incident. They were going through dealing with the fallout of that at that time. So couples go through tough times sometimes. That doesn't necessarily mean you're gonna plow them down in a snowy road going 24 miles per hour in reverse. No, you're not going to do that. The probative value of these statements outweighs any possible prejudicial effect, as the statements are being offered only to prove state of mind and not the truth of what was stated. Any potential prejudice could be remedied through a jury instruction on the limited use of the state of mind. For all those reasons, the Commonwealth respectfully requests it be allowed to introduce testimony of the victim's state of mind as proof of the defendant's motive to take his life. So, once again, Hank Brennan proves that he is just re-prosecuting the same case. He wants Karen Reed's text messages between Brian Higgins and herself. He wants the Aruba sluts to come in the Aruba girls to come in and testify to how horrible and awful Karen Reed was to them, even though she like yelled at them, but or yelled in reference to what was going on, and then later felt bad and like paid for their room or their beverages or something that night. I can't remember. She paid for something that night, and then everyone was like, "Oh, she's so nice," but then you come to court and like, "No, she's terrible because she said mean things to me." Whatever. So he says for these reasons, yeah, they should be able to allow all that stuff, which is so ridiculous. And yet again, we're going to have to sit through weeks and weeks of witnesses that are irrelevant, it seems. Let's move on to the defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude any references to the irrelevant, inadmissible, and prejudicial events that purportedly transpired in Aruba. So now they're trying to get rid of that, which I'm glad that they put this filing in on December 31st. So the things that I was just talking about, the things that happened in Aruba, the Sullivan girls who, I can't remember their names. One of the Sullivan girls and John may or may not have been kissing. I think they were kissing. They may or may not have been handsy with one another at the moment when Karen walked up and discovered that. And rightfully so, she got mad at the situation and said some things. And they're holding that against her and using that as some motive for her to take his life a month later. Makes no sense, but okay. So, as grounds for this motion, the defendant states that the proffered evidence is not relative to any material issue in this case. Should the court find that the evidence is relevant, any potential probative value of the proffered evidence is outweighed by the substantial risk of an unfair prejudice to Ms. Reed. Factual background. Ms. Reed is accused of the following crimes arising from the death of Officer John O'Keefe: homicide in second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death. The defense suspects that the Commonwealth will again seek to admit testimony, and they suspected correctly because they submitted this affidavit at the same time as because they're both of them had their the deadline for motions in limine was this past Monday. So um, they all started getting filtered into the system on Tuesday because there were so many of them. It took so long, and now I forgot what I was saying. But that is so they both had the same deadline. So the defense didn't know if the Commonwealth is going to put this in a motion limine, but they did. So it's a good thing that the defense did this. And the defense's motion is much more thorough and specific. So the defense suspects that the Commonwealth will seek again to admit testimony regarding the completely irrelevant verbal argument between Ms. Reed and a woman named Marietta Sullivan. That's her name. Which occurred in Aruba on December 31st, 2021, for the sole purpose of trying to assassinate Ms. Reed's character. It is the sole purpose of trying to assassinate her character in the eyes of the jury. At Ms. Reed's first trial, every single witness unequivocally testified that there was no history of violence whatsoever in Ms. Reed and Mr. O'Keefe's relationship, and that the two of them were in good spirits on the night of January 28th, 2022. So, like I said, it's even on camera. They were being affectionate, they were in good spirits, they were getting along fine. So, the intent in John's mind, the victim's mind, that night was getting along with Karen Reed and being in a relationship with Karen Reed, or at least for public perception, that's what he was doing. So you can infer that he wanted to keep the relationship going at least a little bit longer. Despite this, the Commonwealth repeatedly elicited inadmissible testimony regarding the verbal incident that occurred in Aruba 1 month prior between Ms. Reed and a third party, which had no logical relationship to the crimes charged. The Commonwealth has no reliable evidence to suggest that the Aruba incident had anything whatsoever to do with the John O'Keefe homicide that happened a full month later, or that this remote and isolated incident was even a point of contention for Ms. Reed and Mr. O'Keefe's relationship after the trip. At the first trial, the Commonwealth called Laura and Marietta Sullivan to testify about a highly inflammatory incident in which Ms. Reed apparently got angry at another woman, not the decedent, because so she got angry not at John, but at Marietta Sullivan because she purportedly believed that Mr. O'Keefe had kissed that woman. The Commonwealth intentionally admitted that this prior bad act and character evidence for no reason other than to sully Ms. Reed's character in the hopes that the jury would indict her based on the fact that she was, in Marietta Sullivan's eyes, an asshole or words. She actually used those words. At trial, Laura, which you can be an asshole in this country. Unfortunately, it's not a crime. But uh, that doesn't make her someone who mowed down her boyfriend in a fit of rage just because you got angry at a situation where you thought your boyfriend was cheating on you. So at trial, Laura Sullivan admitted that she was not present during the verbal exchange between Marietta Sullivan and Ms. Reed, so her testimony about the December 31st incident in Aruba is almost entirely comprised of inadmissible hearsay. Despite the court's limiting instruction about bad character and propensity evidence, the Commonwealth was permitted to elicit prejudicial testimony from Laura Sullivan that Mr. O'Keefe purportedly called Ms. Reed crazy. We don't know that that's true. And that he had insinuated he was unhappy in the relationship. Marietta Sullivan's trial testimony was also extremely prejudicial to Ms. Reed. Her retelling of the verbal dispute with Ms. Reed was not probative of any material fact or element in the case, and it culminated with Marietta telling the jury decidedly that Ms. Reed sucks. Remember, she was like, well, she sucks. As set forth herein, this evidence must be excluded. And here's the argument. The Aruba incident constitutes inadmissible prior bad acts and character evidence, and any potential relevance is outweighed by the risk of unfair prejudice to the defendant. Motions in limine concerning the introduction or exclusion of purportedly relevant evidence are properly made and considered before and during trial in advance of the evidence being offered. The purpose of motion in limine is to prevent irrelevant, inadmissible, and prejudicial matters from being admitted in evidence, and in granting such a motion, a judge has discretion similar to that which she has when deciding whether to admit or exclude evidence. It is a fundamental rule that the prosecution may not introduce evidence that a defendant previously has misbehaved in in, in what is that word? Indictably or not? Indictably, like whether they were indicted or not when they misbehave, I guess is that word. I've never seen indictably, but cool. We learn something new every day. Or not, for the purpose of showing his bad character or propensity to commit the crime charged. Although this type of evidence is sometimes admissible for other relevant purposes, such as to prove a common scheme, pattern of operation, absence of accident or mistake, identity, intent, or motive, these exceptions are not without limitation. Similarly, although evidence of a hostile relationship between a defendant and his spouse may be admitted as relevant to a defendant's motive to take his life, such evidence should not be admitted if it relates to events which occurred at a time too remote of the homicide. Animosity between husband and wife 3 years before the homicide was too distant to be probative of the husband's motive. In Commonwealth versus Burke, evidence of defendant's husband's adulterous relationship, which terminated 7 months before the wife's death, was not probative of the motive to the homicide. So his affair, which ended 7 months before his wife's death, was not it was not admissible to be used for the homicide for a motive. Temporal remoteness is not an exercise in line drawing. Rather, a reviewing court focuses on the logical relationship between the prior bad act evidence and the crime charged. Here, there is no logical relationship. In order for evidence of a prior hostile relationship to be relevant to a defendant's motive to take his life, to take a victim's life, the evidence must actually establish a prior hostile and violent relationship. So you must establish a prior hostile and violent relationship between the victim and the defendant if you're going to bring in hostile relationship material. Prior acts evidence included police testimony about a domestic dispute requiring law enforcement response and witness testimony about multiple physical disputes between defendant and victim in order to show the nature of the relationship. Evidence including defendant's prior arrest for domestic violence, multiple restraining orders, and pending divorce proceedings was admitted to show the nature of the relationship. So you can, when you have a clear-cut history of violence, restraining orders, police reports, all those things, then you can bring it in. But if you don't, you can't. Evidence of defendant's prior threat to stab a victim to death was introduced to show the nature of the relationship. Evidence including extreme physical violence, multiple emergency room trips, and threats to take the victim's life was admitted to demonstrate the nature of the relationship as well as defendant's intent, motive, and absence of mistake. Evidence including extreme physical violence and threats with a firearm was admitted to show nature of relationship and motive. The case law is not comparable to this incident during which Ms. Reed briefly became angry with another woman, not the decedent. So it's not even the decedent that we're talking about here, because she believed that Mr. O'Keefe had kissed that woman, Marietta. There was zero physical violence here, no threats of violence, no police involvement necessary, and absolutely no history of violence in Ms. Reed and Mr. O'Keefe's relationship. Moreover, even when this type of evidence might be relevant for some limited purpose, the evidence must be excluded if its probative value is outweighed by the risk of unfair prejudice to the defendant. We have a very long footnote here. It says Section 404(b)(2) permits the court to exclude evidence of a crime, wrong, or other act that is offered for a proper purpose to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if the risk of unfair prejudice simply outweighs the probative value of the evidence. So, what they're saying is, even if this is totally permissible, there's nothing wrong with it, and there's no reason why it shouldn't come in, a judge still has the discretion to exclude totally proper evidence because it might unfairly prejudice the defendant. So she still has total, basically, judges have the ability to do whatever they want, is what I'm learning from this case. All right, this is more exacting standard than the standard set forth in Section 403, excluding relevant evidence for prejudice, confusion, waste of time, or other reasons, which permits the court to exclude relevant evidence if the danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence substantially outweighs the probative value. Compare Evidence Code 403 with Evidence Code 404. That is because bad act and propensity evidence is inherently prejudicial and the risk of improper use is enormous. So this is a big issue if she lets this in. It is a bad, it can severely prejudice a defendant. No duh, and it did. And the first time around, and that's why they did it. So, where offered to establish motive in prosecution for first-degree homicide, testimony regarding the charges in the defendant once he began using drugs including the statement that the defendant had become a little more violent, was more prejudicial than probative. All right. Indeed, Massachusetts courts have long held that where evidence of prior bad acts is relevant for purposes such as intent or motive, it should be excluded of its if its probative value is outweighed by the risk of unfair prejudice to the defendant, even if not substantially outweighed by the risk. So, even if it's not a substantial risk, it should still be it should still be excluded. Hear testimony by Marietta Sullivan that Reed became angry with Marietta, not the decedent, on. I love how they keep throwing that in there because they're reminding Judge Canoni, hey, it's Marietta's talking about something that has absolutely nothing to do with John O'Keefe. Because she believed that Marietta had kissed her boyfriend, John O'Keefe, is simply not probative as to whether Ms. Reed had an intent to take the life of John O'Keefe on January 29th. This event was remote in time and was clearly not an issue between O'Keefe and Ms. Reed on the night in question, as evidenced by video surveillance footage from the Waterfall Bar and Grill on the night in question and the testimony of 8 witnesses, all whom agreed that the couple appeared happy and in good spirits. So that doesn't seem like someone who wants to break up. And even if he did, so what? It doesn't matter because you can't really confirm it. It's all hearsay, and you're just using it to try to like paint Karen Reed as a bad person. He wanted to dump her anyways, so whatever. There is no logical relationship between the Aruba incident and the crime charged. The Commonwealth's attempt to characterize this misunderstanding as some sort of turning point in Ms. Reed and John O'Keefe's relationship is off base and unsupported by the evidence. The sole purpose of the Commonwealth's attempts to admit this evidence is to sully Ms. Reed's character by allowing Marietta Sullivan to testify that Ms. Reed sucks. If we are to believe the Commonwealth's best evidence that Ms. Reed said, "Go F yourself" to Marietta when she temporarily believed that she observed Marietta kissing her boyfriend on New Year's Eve in Aruba, that evidence is simply not probative of a homicide of Mr. O'Keefe more than a month later when the parties were, by all accounts, in good spirits. In order for there to be a logical relationship between the prior bad acts evidence and the crime charged as required by Commonwealth versus Pino, the jury would need to believe that Ms. Reed reacted with a verbal "go F yourself" when she believed that she had observed adulterous behavior on December 31st, but then subsequently flew into a murderous rage a month later when this event was remote in time and not the subject of any arguments on the night in question. If anything, they were arguing about the fact that they just keep arguing. That type of reasoning defies logic. A lot of their arguing had to do with kids, and some of it raising the kids, some of it just, his questionable, um, probably drinking habits and leaving her to watch the kids and things like that. So I think that's where a lot of their relationship stuff came in. And he was a ladies' man, like I said, so that probably caused she's an outsider. There were tons of Canton women who just were fawning all over John, so that didn't help their relationship either. So the Marietta thing is one isolated incident out of many compounding things that were causing issues in the relationship, but as you could see, they were still together on the night of January 29th. And surveillance video and witnesses all corroborate that. All right. So when this event was remote in time and not the subject of any arguments that night, that type of reasoning defies logic. Ms. Reed's short lived anger was not even directed at Mr. O'Keefe, and her apologetic conduct after the incident demonstrates that she knew the kiss could have been a misunderstanding. The only reason for the admission of this evidence is to sully Ms. Reed's character and prejudice the jury against her. her apologetic conduct after the fact and trying to pay for their room or their I don't remember if it was a room or what. She was paying for something for them, like offering to pay because of the fact that she blew up at Marietta the next morning. She offered. All right, so Ms. Reed reasserts here that this evidence has no probative value regarding the crimes for which she had been indicted. However, even if the court finds that this evidence is relevant, any marginal relevance of Ms. Reed's temporary belief that O'Keefe kissed another woman 1 month prior might have in terms of evidencing a hostile relationship or intent to homicide is far outweighed by the prejudicial inflammatory effect it will have on the jury. The Commonwealth must be prohibited from calling witnesses to testify to inadmissible hearsay for the purpose of attempting to show a hostile relationship. Like, let's not call Laura Sullivan simply just to rehash some hearsay that's unsubstantiated. Moreover, Massachusetts courts have long held that the omission of hearsay statements for the purpose of showing a hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. The Commonwealth's argument in prior proceedings that the testimony is admissible in order to show the defendant's state of mind is misguided. Again, the events in Aruba took place a month before John O'Keefe's death, and there is no evidence to suggest that Ms. Reed was still upset about it the night of January 28th, going into the 29th. Here, testimony by Laura Sullivan regarding the irrelevant and inherently prejudicial Aruba incident must be excluded because this witness has nothing to testify about other than inadmissible hearsay and prejudicial character evidence. Indeed, during the 2024 trial proceedings, the Commonwealth chose to put Laura Sullivan on the stand to testify about an incident that she did not witness in Aruba. So again, Laura Sullivan, sister of Marietta Sullivan. Marietta is the one that John was supposedly kissing, and Laura was not present at this time, but she came onto the stand just to testify to this incident and to say that later John and her spoke and he called Karen crazy and he told her he wanted to break up with her. And that was the extent of her testimony, which is all hearsay and inadmissible and unsubstantiated. All right, so Laura Sullivan was also permitted to testify about her completely irrelevant negative impressions of Karen during the planning of the Aruba trip. Oh, yeah, I forgot about that. I.e., that Karen told her she needed her own bathroom and that she didn't want to share the room with John's kids. And that was because of her medical issues. And that really has nothing to do with anything. But Laura Sullivan made it all like, oh, well, she was very difficult. Commonwealth then elicited the Commonwealth then elicited additional inadmissible and prejudicial hearsay testimony from Laura, who told the jury that Mr. O'Keefe told her that Karen is crazy during a later conversation on the night of December 31st, and that on January 2nd, John insinuated that he was unhappy in their relationship. Note, this unhappiness was allegedly communicated non-verbally and solely via Mr. O'Keefe's body language, namely a shrug and an eye roll. Not only is this inadmissible hearsay, but it's an interpretation of a gesture, not an assertion of actual words that Mr. O'Keefe said to Laura, and thus calls for speculation, so that should have never come in. This judge is ridiculous that she even allowed this the first time. And she's probably going to allow it a second time because she just loves to make Karen Reed look bad. So she probably will allow it. Notably, Massachusetts courts have long held that the omission of hearsay statements for the purpose of showing hostile relationship between the defendant and the victim is not permissible because it would entirely eviscerate the rule's important purpose of securing the correctness and completeness of testimony through cross-examination. I feel like I read this already. Thus, all of Laura Sullivan's testimony should be excluded um, regarding the Aruba trip, which constitutes prejudicial and inadmissible hearsay. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court exclude any reference to the December 21st incident in Aruba. And finally, this is a very short one. The Commonwealth's motion in limine to introduce certified records from the Registry of Motor Vehicles. Wait, I forgot. No, this is not what I didn't want to go through this one right now, but here it is. So, here it is. So, motion to eliminate from the Commonwealth to introduce certified records from the Registry of Motor Vehicles. The Commonwealth respectfully requests that this court, I did want to do this in this episode, and this is why. So, the Commonwealth respectfully requests that this court issue a ruling in limine that the Commonwealth may introduce certified copies of records from the Massachusetts Registry. Darn it, I can't keep a straight line. The Commonwealth they want to introduce certified copies of records from the Massachusetts Registry of Motor Vehicles. So, did she get into an accident? This is what I'm thinking. She got into an accident or she has speeding tickets from the past, and those things they want to bring in to say she's reckless at driving. So this is more bad character evidence, I would say. That's why I put this in this episode now that I remember. I would say this goes to more bad character evidence, which they don't want coming in for their witnesses, the Commonwealth, but here they have it for Karen Reed. They want to get her motor vehicle records to see if she has any accidents or priors, anything on there. They want to bring in the Aruba chicks and have them testify for hearsay and about what a crazy person John thought Karen was and that he wanted to break up with her, which was never actually even said. They want to bring in statements from other family members, nieces, nephews, text messages from Karen Reed herself to Brian Higgins, where they kissed in the garage and had a couple flirtatious text messages back and forth, but Brian Higgins has no game and she got really bored really fast, so she left. She's like, I'm out. She ghosted him. So that's where we're at for the bad character evidence. I hope you guys enjoyed this episode. Please hit the like button on your way out. I have many more episodes to go through because there are so many filings, and I'm sure today we're going to get even more because we didn't get them all published on the docket. So, I will keep you guys posted as we go along. Thank you for watching. Please make sure you are subscribed as we go through all of the court documents in the Karen Reed case on this channel. And I will see you guys in the next one. Thank you so much again for watching. Take care. Bye now.